and but don't necessarily have a mental health issues. But realizing that competency, being found incompetent, can be a tool and means to avoid having to ultimately stand in front of the altar of justice. A lot of individuals feign competency so that they don't have to stand trial. And as a matter of fact, I passed out for everybody to have there to review a manifesto that was circulating in our jail that we recently discovered as to how to be found incompetent. As a matter of fact, this was authored by several of the inmates in the jail at the time, circulated so that individuals who were waiting to be evaluated by court-appointed psychologists could try and take the steps necessary to be found incompetent. So, but one of the reasons why we're here is to get some ideas as to what, from my perspective at least, things that can be changed. How can we improve this scenario with respect to what we're doing right now? Now, the state of Florida is one of 16 states that allow individuals to be treated in the community who are found incompetent to proceed. 34 of the states in this country all require everybody who's charged with a felony to go to a forensic hospital. 34 states require everybody, no matter what they're charged with, if it's a felony, they have to go to a forensic hospital. Now, what is the result of sending somebody to a forensic hospital as opposed to treating somebody in the community? We did a study in Broward County for a 3-year study with respect to the rate of restoration to competency of individuals treated in the community compared to individuals who were sent to the state hospital. And for the 3-year period, we found that in 1 year, 62% were restored to competency that went to the forensic hospital. The following year, 74%, and the year thereafter, 78.5% of the individuals that were sent to the forensic hospital were restored to competency. With respect to individuals that are treated in the community, it's startling. In year 1, we had 18.5% that were restored to competency. In year 2, we had 19.6% that were restored to competency. In year 3, 21%. So the bottom line is, and when you stop and think about it, treatment in the community is so much different than treatment in a forensic hospital. I've been to Chattahoochee, the Florida State Hospital, at least 4 times, walked the grounds, seen the facilities, and the orientation in a forensic hospital is for treatment. With respect to treatment in the community, we don't know whether the individuals are getting their psychotropic medication. No one is really eyeballing them with respect to whether they're taking their psychotropic medication, because psychotropic medication really, when push comes to shove, is a difference maker with respect to whether or not someone's going to be stabilized or not stabilized. So in the community, we don't have that ability to determine that, number one. Number two, unlike the state hospital where they're under 24 hours, 7-day-a-week treatment by psychiatrists, psychologists, case managers, nurse practitioners, peers. We don't have those opportunities with respect to treating somebody in the community. So as far as I'm concerned, the treatment in the community is lacking because we don't have the money to have programs, residential programs, or at least enough bed to have sufficient residential programs for individuals who are found incompetent but don't meet the requirements to be committed to a state hospital. And by the way, to be committed to a forensic state hospital, you have to be a danger to yourself or others or a risk of self-neglect. And you have to have the potential for being restored to competency in the foreseeable future. If you don't meet those requirements, you can't be committed to the state forensic hospital and you have to be treated in the community. And so the majority of people are treated in the community because not everybody meets that requirement. And as you can see, as I just indicated to you, the success that we have of treating people in the community leaves a lot to be desired. So we have to actually step back and ask ourselves, is it worth the additional money? Because certainly it costs a lot more money to treat somebody in a forensic hospital as opposed to treating them in a community. Is it worth the additional amount of money to have a higher percentage of these individuals restored to competency and therefore get their cases resolved? Because the people who are treated in the community that have a mental health issue, that are charged with felonies, they're lingering there. Because right now, the statute for dismissal of charges with respect to someone who is incompetent, I was successful in trying to get that reduced from 5 years to 3 years. I wanted it across the board in front of the legislature, but they agreed to reduce it from 5 years to 3 years with respect to dismissal of charges for people that are found incompetent who are charged with non-violent offenses. If they're charged with violent offenses, it still remains at 5 years. So the bottom line is, we have individuals that are lingering in the community for anywhere from 3 to 5 years who have pending felony criminal charges that we can't get them restored to competency. And so we're continuing to throw bad money after bad money to try and treat these people, and it's just not working. Most states around the country authorize the dismissal of charges for individuals who are incompetent to proceed anywhere from 6 months to 18 months. Because there's no epiphany that's going to happen in year 2, 3, 4, and 5 that someone is automatically going to be restored to competency. It just doesn't happen. Especially if they go to the state hospital. If they go to the state hospital and they're not restored to competency after a certain period of time, then they're going to notify the court that the person's not restorable. And if they're charged with a violent, serious crime, that doesn't mean the door opens up at the forensic state hospital and they walk out and the community's in danger. They start the proceeding to have this person civilly committed. And when you're civilly committed, there is no 5-year limitation. You can stay in a civil mental health hospital for the rest of your life until it's determined that you're no longer dangerous for a risk of self-neglect. So I'm just throwing that out there for a suggestion that no question is going to cost a lot more money to have everybody go to, and it may sound like a horrible remedy to a solution that is necessary to be addressed, to have everybody go to the forensic hospital who's charged with a felony. But if you want to have these people restored to competency more quickly so that they are in a better position to deal with their pending criminal charges, then sending them to the state hospital, as far as I'm concerned, is the best result. Now, another thing that I think to address the issue of the constant flow of people coming into the criminal justice system, many of whom are incompetent, is improving the utilization of the Baker Act. Now, there is no mandatory obligation that police officers bring individuals to a crisis unit or receiving facility. Most of them out of convenience because it's expeditious and it's less.
This is live today.
Less taxing to their time. They bring people to the jail. They arrest people and they bring.
This is the man's voice on that intercom.
People who are charged with non-violent felonies, because if you're charged with a serious violent felony, a receiving facility or crisis unit doesn't have to take you, and that's specifically in the statute. They don't have to take them if they feel that they cannot handle someone who is charged with a very serious crime. But if they're charged with a non-violent felony offense, I believe that if we can encourage and even mandate police officers to bring people to crisis units or receiving facilities, and if in fact the crisis unit receiving facility is able to stabilize these individuals, then they're more likely than not going to be the state attorney's office or prosecutor's office, if they don't have an extensive record, if it's a non-violent felony, they're going to consider putting him in some type of diversion program or not even file the charges against him once they're stabilized. So I throw that out there as another suggestion to you, that we really need to beef up the utilization and actually mandate that police officers under certain scenarios have to bring people to crisis units and receiving facilities. But one other shortcoming of the Baker Act a crisis unit is the following. Now we have in the statute all these statutes that mandate transportation plans with respect to transporting people to a Baker Act facility and crisis unit receiving facility, and we have a statute that specifies who's responsible, the sheriff, to transport people from the jails to the forensic hospitals. But we have nothing in the statute that addresses the issue of transportation of people who are discharged from the crisis unit receiving facility to a community mental health agency where they can be linked up with. Because normally when you're released from a Baker Act crisis unit receiving facility, you're given a script for psychotropic medication, and then you're told, go get us filled and go see your community case manager, or go get linked up with a community case manager. Most of these people don't have cars, most of these people don't have bus passes, most of these people don't have any means of transportation at all, and many of them are homeless. So all I'm suggesting is, if we're going to go the route of improving the utilization of the Baker Act, that we really need to have in place a more effective measure of, once they're discharged from a crisis unit and receiving facility, to ensure that they can get transported to a community mental health agency where they can be linked up with a case manager. We can be assured of that, and also get their psychotropic medication. Half these people, once they're stabilized and discharged, they never take any more psychotropic medication. They don't have any means of getting to a pharmacy or getting it filled. A couple other suggestions I want to just talk about, and that is that right now the Florida statute authorizes judges to appoint up to 3 psychologists with respect to doing evaluations. As far as I'm concerned, it should be just 2. And the reason why I say that is a lot of times it turns out into a jockeying between the public defender's office, who represents most of these individuals who appear in mental health court. They represent at least 80% of them. And whether it's going to come out of their budget or it's going to come out of the court budget. And more often than not, if we appoint two psychologists to do the evaluations, let's just say they have a split. One says the person's competent, the other one says the person's incompetent. Or they both say the person's incompetent, but one says it should go to the state forensic hospital, and the other one says the person should be treated in the community. Well, they come back to the court and say, Your Honor, will you appoint a third doctor to do this? Why should we do that? Why should we have to do that? Well, it's very tempting to do that as a judge, because if you can get a tiebreaker, then you can save yourself going through a 3-hour competency evaluation hearing. But normally what happens is a lot of judges will nevertheless go ahead and do that, because they don't want to have to spend 3 hours going through a competency evaluation, a contested competency hearing, and they hope that by having a tiebreaker, both sides will stipulate as to whether or not there's a basis to find the person incompetent or competent, or whether to send the person to a forensic hospital or treat the person in the community. So I'm suggesting that the courts should only be authorized to appoint 2, and if in fact the defense counsel, for whatever reason, feels a third one needs to be evaluated, they should pay for it. The court shouldn't have to pay for it. Another thing that I feel needs to be looked into is there is a growing sentiment among psychologists that in fact there should be a different standard between competency to stand trial and competency to enter a plea. Now, Mr. Gottlieb has appeared in front of me a number of times in mental health court, and he can tell you as a criminal defense attorney, there's a lot more involved when you have to prepare not only yourself but your client to go to trial, as opposed to taking a change of plea. So a lot of doctors who do evaluations have expressed to me that if in fact there was a different standard, that in fact all they needed to do was determine whether the person was competent to enter a plea, as opposed to competency to go to trial, that they would find that person competent to enter a plea, because there's much less that's required of the defendant than is required if in fact the defendant has to go to trial. So I urge you to look into that, because I think that if in fact there's enough support for that and there's enough legal authority for that, that would possibly resolve some of the problems we have with respect to people lingering in the system for too long of a period of time. Another thing that I think is very important is with respect to the period of time, and I talked about this briefly, that individuals remain under court supervision that are found incompetent to proceed. 5 years, even for violent offenses, is too long. It's too long. There's no reason why they should be in the system that long. As I say, if you're going to restore somebody to competency, it's going to occur within the first 6 months to 18 months. And most of the states, the vast majority of the states, authorize dismissal of the charges in a much shorter period of time than 5 years. Nothing's to be gained. And by the way, under the statute that we have now, and under the statute that I suggest should be amended and enacted that would reduce the amount of time, you're still authorized to, the prosecutor is still authorized to refile the charges if in fact at a subsequent point in time the defendant becomes competent. So let's just say that charges are dismissed against an individual after he's been in front of the court for 2 years. continuously incompetent, and then he gets rearrested 2 years later, and he's found competent to proceed 2 years later. Well, not only could he be prosecuted on a more recent charge, but the charge that was dismissed, because it's dismissed without prejudice, can be refiled against this individual if in fact he's now found competent. So I urge you to consider that as another alternative way of addressing the problems that we have.
Judge, if you could kind of wrap up quickly, and then I want to hopefully have time at the end if you have some additional remarks, but I want to try to get to a couple public comments and the committee
Okay.
and the panels. Oh, by the way,
I'm all set. Thank
okay,
you.
okay, thank you, Judge. Let's see what we got here. Any brief questions for Judge Spicer before we proceed? I want to make sure we leave time on the back end. All right, we have Art Cooksey, Let's Talk Interactive. Okay, I'm sorry. Representative Lamarca, question for Judge Spicer.
Thank you, Chair.
Come on up, Art, but let Judge Spicer respond to this question. Go ahead.
Quick question, as the, I don't know if the judge is still a constituent of mine or not, but is a fine judge in Broward County. There was something we covered earlier with regard to the veteran case that was the Jane Doe. We have a Veterans Court in Broward County. Does the Veterans Court work in conjunction with Mental Health Court and those specific cases?
Yes, it's always important when you have a veterans court, if you possibly have a judge that is a veteran, to have that judge preside in a veterans court. We happen to have somebody who was a brigadier general, okay, in the Army Reserve, who was actually presiding over our veterans court. So if in fact there's an overlay between the issue in veterans court and mental health, we work together on that. But obviously, they have the benefit of having the resources of the VA, and they have a lot of more resources than we do available to them with respect to treatment of veterans.
Okay.
Thank you very much.
Thank you.
All right, Mr. Cooksey, you're recognized.
Thank you so much for the time. Thank you, Chair Menier, and everyone here. It's really an exciting time to be in telehealth. And my name's Art Cooksey. I'm the CEO of Let's Talk Interactive. We are a telehealth solutions company. We have been doing some work in the state of Florida. We started in the jails in Franklin County and 5 other counties. And we started with the medicated assisted treatment program, but also putting kiosks in for mental health assessments, as well as med carts to help in the infirmaries and with the medicated assisted treatment program. And it's really starting to come along. I mean, in the last 5 months, I think there was 52 sessions with 954 minutes of telehealth services